All right, a couple of things, or just one thing, is that I sent you out an email that there's no office hours today, so I have to be gone out of time. I also added an article in the Law and Economics folder called Law and Macroeconomics. So it's sort of an interesting, there's another article, actually a little set of articles that's in there as well, but this one is newer and it's just called Law and Macroeconomics. So it's an interesting law and economics application in the macroeconomic field. So you might want to just take a look at that, especially if you're, again, thinking about what you might want to be doing for your paper. All right. So last time we were talking about efficient breach, right? I mean, the idea is that, and it's sort of like when we were talking about when you could basically get a property right by trespassing on the property and paying compensation. Similar idea here that you can breach the contract, and if it's more efficient for that to happen, then we'd like that to happen, right? And what would be an efficiency condition would be if the cost of performing is greater than what the expectation damages are, right? The idea, again, was to have, one of the remedies was perfect compensation, right, for your expectation, what I could have earned from the program. And if what I could have earned from the program is less than what it costs to you fulfill, then it doesn't make sense for you to fulfill, right? You should be able to just say, okay, I'm paying the damages and get by with it. And again, if we're sort of thinking about costs, it may be that if the transactions costs are low, the parties will renegotiate, right? They'll say, okay, why don't you do this? It'll be a little, it'll be a different band or something, it's some sort of company that has lots of different bands, and maybe it'll be better to just go ahead and, we can gain from the two of us by renegotiating the contract. So and basically what you'd be doing is splitting up that surplus, right? There's a surplus from the breach in the sense that if it's less expensive to breach, then you'd just sort of be dividing up that surplus a little bit. So let's take a look at, again, we were talking about further discussion of things, and let's say we're just making some comments on what about an unforeseen event, right? So something happens, it causes a problem, and we didn't think about it. And of course, we said that you can put you can't put everything into the contract, right? It would just be too expensive to try to think all the things that could happen. So it's reasonable to assume that there's going to be a problem at some point. And again, you could pay expectation damages, or what the court could do, right? So the court could say, pay these expectation damages, or it could say specific performance, right? We could say, okay, you have to perform. And if you were to think about it, it's like a compensation versus injunction. If we were thinking back to when we were talking about property rights, early on in the semester, do you have to perform the thing, or can I pay expectations? Now, if you sort of think about it, damages will always be efficient in the sense that I wouldn't perform if it was more expensive to perform than what the promisee could get from whatever the contract was, right? So what we said that, what's an efficient, right? An efficient breach, we just said, okay, what's going to happen? The expectation is less than the cost of performance, right? So I would rather, so if I have an ability to make that choice, if I'm the promisor, then I would choose to breach the thing. But what if the court's making that decision? If the court makes the decision, then if you sort of think about it, damages will always be efficient, right? Because, I mean, it's sort of obvious, but why is that? Because the promisor will choose that, right? The promisor will choose whichever's less cost, right? If the court instead required specific performance, then you might get it right, right? It could be that specific performance is less than what the loss is from a specific performance is less than the compensation. But what if you had specific performance, and what if the cost? What if you had the cost of performance is greater than the expectation, right? Well, then you'd get it wrong, right? So if you sort of think about it, it's very much like when we were talking about injunction versus damages. That is, it's possible I'd get it right? It's possible that the party who valued it at most, it would go to that. Remember we were talking about that? But if the transactions costs were high, what would happen? It would stick with that one, and you might get it right. Similarly here, if I give specific performance, so I'm requiring the specific performance, then it might be that I've done I've created a situation where I've required you to perform what in fact the cost of performing is now greater than what the expectation performance would have been. And so you're going to have an inefficient situation, right? So sort of, again, think through that. Damages will always be efficient in that the promisor can figure out, okay, it's costing me more to fulfill this thing than the promisee is going to get, right? It's possible that it doesn't cost me as much, right? In which case I wouldn't breach, right? If for me it was less costly to go ahead and perform, you had an unforeseen circumstance, but it's still less costly to perform than the amount that the promisee is going to get from the performance going on. Okay, that's what I would do. So damages will always be efficient, but a specific performance, I might in a sense, give the property right to the wrong person, right? I might have created a situation where I've required you as the promisor to fulfill a contract where it's more expensive for you to do that than the promisee is going to get from what happened with the contract. Again, if there's low transactions costs, what might happen is the parties might renegotiate the contract, right? You could require specific performance, and then we get together on the side. The court's requiring specific performance, and you get together on the side and say, "Hey, why don't we rewrite this thing, right? And we'll divide up the surplus from performing it from the efficient remedy." Suppose that instead you have a fortunate unforeseen result. That if something happened or excuse me, a fortunate unforeseen event. Well, then what happens is, so something's happened and now it's beneficial that in a way that you didn't think it was going to be. So let's give an example. Okay, suppose that you have a contract. We'll call them persons A, B, and C. Okay, so A, this as an example. So A has a contract to sell the house to B. Okay, and then C comes along and says, "Oh my gosh, I'd really like to have that house. I didn't know it was for sale. I'm going to give you $50,000 more than goes to A and says, I'll give you $50,000 more than B." Okay? So what do we know? We know that C ought to end up with the house, right? I mean, if you sort of think efficiency. So we have a situation where C values the house more than B, offers more to A. Okay? So the fact that A was already going to sell it to B tells you what? It tells you that B wants the house, values the house more than A did. Otherwise, they wouldn't have had the contract. Okay? So now we know that C values it more than B because C is willing to pay more than B for the house. Okay? So what do we want to know? Or what do we want to happen? So C values it the most. So it should end up with C if we're going to be efficient. Okay? Now, suppose that we give specific performance. Say, okay, court says specific performance. Well, then what's going to happen? A is going to sell to B, right? That's the specific performance. So A sells to B. But then what happens? B sells to C. So C ends up with a house, right? Now, what if we have damages? Okay, instead we do damages. And remember that if we have expectation damages, what are we doing? We're paying the promisee what they expected to get from the contract being fulfilled. So if B expected to give or to sell the house to C, right? So if we say B expected to sell the house to C, then what's going to happen? A's indifferent, right? A's indifferent between specific performance or they sell the house to C, and then what do they got to do? They got to pay the damages to B, and what do they got to pay, right? They got to pay what B would have got, and so they end up with the same thing that they ended up with, or that they ended up with under specific performance. So what happened here is A is going to be indifferent. Right? They can, and so what will happen is they'll either they'll just sell the house to B, right? And then B will sell it to C. Or they'll just, if they sell the house to C, then what they got to do is they got to pay B the extra that they would have got. And so they're indifferent between what they're going to do. Okay? So either way would get you to the correct answer. Now, what if B was thinking about they weren't going to sell the house, right? What if B was going to keep the house? Then the expectation damages would be different, right? Because you got to pay what B expected to get. If B wasn't thinking about selling it, right, and B's going to keep the house, what would you do? You'd make, and you violate the contract and you sell it to C, okay? You got to pay B the expected value from the house, but they valued it less, so you'd be able to keep some of it, right? So if B was going to expect to keep the house, then you had just A has to pay B the value to the house to B, which is what they were gonna get if they'd had the house. Okay. Well, what's the deal here? How do I know what B was going to do? If you're the court, how do you know what B was going to do? You don't know whether B was going to keep the house or whether B was going to sell the house to C, right? If you somehow knew that, then your expectation damages would be different, right? The expectation damage would be smaller if B was going to keep the house. But it's hard to evaluate that, right? So it's simpler to do, and it's going to end up with C anyway, right? If I got to pay expectation damages which are less than what the difference is that I'm getting from the house selling at the C, I'm gonna pay the expectation damages to sell the C, and I'm better off, as opposed to being indifferent. So if B was going to keep the house, I'd go ahead and sell it. I'd violate it. I'd sell it to C. If I have to pay the expectation damages where B was going to sell to C, then I don't care. I'm going to come out the same. Okay. So because specific performance is easier, that would make sense to do. Right? It's simpler. Right? You don't have to know B's expectation. Right? I don't have to know the value of B's expectation. So if you have specific performance, and B just keeps the house, right? And the problem would be, of course, that maybe it doesn't get to C because B doesn't know what's going on, right? But it's easier to do specific performance, so you tend to do that. That leads us into the next issue. Again, we're just making comments on the things that we talked about. That's how all the chapters work, right? You start out with this discussion, and then you go into maybe making comments on the things that we talked about in the chapter before. So let's think a little bit about what's called the paradox of compensation. And the paradox of compensation is just something that we've already come up with. That is, what happened under tort law? Remember? Under tort law, if you're compensated, if you're perfectly compensated, what's going to happen? The potential injury is not going to take proper precaution. Right? That was the problem in tort law, is that if I have strict liability, then what's going to happen is you, the potential victim, aren't going to take proper precaution. If I have no liability, right, the potential injurer will not take proper precaution. So we said, well, you can't get both at the same time. So what do you have? You have this idea of negligence. Okay? And we showed that, okay, where you make negligence where there's a sudden drop in what's going on in terms of who becomes liable, each party knows that the other party is going to be at that efficient position. So for the potential injurer, they know it's going to be strict liability on them, and if they don't hit the efficient spot. And for the potential victim, they know there's no liability if they don't hit the efficient spot. And so they're both going to take the efficient position because of this big drop in what the costs are to them. So you get a similar thing that this is like, again, like tort law, or how do you get efficient precaution? Or we also talked about, when we were talking about insurance, this was this issue of moral hazard, right? And we said, how do insurance companies deal with the fact that once they've insured you, you won't take as much precaution about something happening? So we said that insurance companies would have deductibles, or they'd have where you get a reduction in your premium if you're a safe driver, or if you have if you have smoke alarms in your house or whatever, right? So it's a similar idea that once the how do we get both parties to take efficient precaution? Because if the liability of breach is higher, right? If the liability of breach is higher, then what's going to happen is the promisor will take more precaution against the breach. Right? They'll have a backup band, or they'll have something, or they'll have helicopters ready to fly the band in there if there's a traffic jam or something like that, right? Now, if damages are reduced, right? If damages are reduced, then what's going to happen? The promisee will take more precaution. All right? So again, it's like strict liability and no liability. When the damages are high, the promisor, are going to undertake precautions to make it so that there's not a breach. Whereas if the damages are lower, then you have as the damages are lower, you have more efficient precaution being taken by the promisee. So again, what we're really dealing here, right, with is over-reliance too, right? When we were talking about the problems with reliance, that is, I'll have a tendency to over-rely, and if I over-rely, then the potential damages from the breach are higher than if I don't rely so much on it. I have a backup band or whatever. It'll reduce the reliance on or the cost of the thing happening. So. Perfect expectation damages gives you efficient precaution, right? If I have perfect expectation damages, just like when I had perfect compensation for tort, right? If I have perfect expectation compensation, then what am I going to get? I'm going to get efficient precaution by the promisor. But what's the problem, right? Then I'm not going to have as perfect a precaution by the promisee, right? So basically, it's not much there's not much incentive for the promisee to take precaution, right? So when we were talking about reliance, the reliance issue, right? They'll tend to over-rely, right? They'll, if they know that they're going to be perfectly compensated for what could happen, they'll have a large venue instead of a medium-sized venue or whatever, right? And so, so the problem here is, if I had no compensation, right, then it's going to be like no damage in tort law, right? If I know I'm not going to get compensated if I over-rely, then what's going to happen is I'm going to make it so that I have efficient precaution against this over-reliance issue. So the problem here is there's no way to get both. There's no way to get perfect expectation compensation and efficient reliance. Or efficient precaution, we'll put it, efficient precaution by the promisee so they don't over-rely. Right? Or even, I mean, that was just one part of it, right? It's not just to make, the other thing is they just might not take precaution against the unforeseen event, right? There's no way to make it so that they don't over-rely or take precaution against an unforeseen event. So you can't do it, you can't have both at the same time. So that means that contract law, unlike the tort law, right, we figured out negligence was a way to get around this efficient precaution on both sides in the tort law. There's not a good way to have efficient precaution in contract law. What does that mean? Well, just like everything else that we've been talking about, right? You may not get it perfect, but you might know that, hey, you know what? Maybe it is, maybe in this particular instance, the promisee isn't likely to over-rely anyway, right? Or maybe you know that the promisor has a better idea of what might happen if there was an unforeseen event, right? So in that case, if you had a situation where the promisor had a better way to figure out what might happen as an unforeseen event, then what would you do? You'd put perfect expectation, right? If you had a situation where the promisee was more, you know, where the promisee could like super over rely, okay, and then you might say, hey, we're not gonna, you know, we're gonna go back and we're gonna just provide you with restitution, right? Because, you know, we had all these things that they could do. Maybe we just go ahead and say, hey, we're just going to do restitution, or we'll just do reliance when you think that the promisee has a lot more ability to know what might happen than the promisor did. Then you'd want to like move the, you know, you want to move some of you want to internalize those costs, right? And so again, you're not going to have a perfect solution, but it gives you some guidance about what the court might want to do when they're looking at the contract. You could attempt a negligence standard. You could attempt a negligence standard, but difficult to do. Right? If you think about negligence standards, how you could do that, you know, in accidents, maybe okay, 25-mile-an-hour speed limit, that works pretty well here because we've seen how this all works, you know, over and over again. Contracts might be relatively unique, so it might be hard for you to figure out, oh, yeah, they were negligent here, right? So it's going to be difficult to, what if you know, we talked a little bit about you could put into the contract something like we'll do our best effort or something like that. Well, that's going to be relatively hard to figure it out. You could award hypothetical expectation damages. hypothetical expectation damages. And what would that be? You'd say, okay, here's what the expected benefit would have been if the promisee had undertaken proper precaution, right? So you could say, instead of expectation damages, you'd do hypothetical expectation damages, in which case you'd have to figure out what the return would have been, right, without breach, if the promisee had undertaken proper precaution. Now again, there might be a situation where that's sort of obvious, okay? Or it might be a situation where you're pretty clear what was going to happen, but in general, that would be hard to do. In a sense, what are you trying to do here? What are you trying to do with these expectation damages? You're trying to put the promisee into a situation where they would have been if the breach had not occurred and they had taken proper precaution. That's what you're trying to do. Instead of saying, we're going to put you in the place where you would have been had the breach not occurred, we're going to say, we're going to put you in a position that you would have got if you had not, if you had taken proper precaution. You had not over-relied and you had, taken into account that these unforeseen events could happen. So let's just have some comments again now on when the court sets aside terms of contract or the court adjusts an imperfect contract, right? We talked about the court could set aside, this is these comments here. If the court sets aside the contract, says, no, this isn't a viable contract, or it modifies the terms of the contract. Remember we talked about the fact that the court could come in and fill in the gaps or whatever, right? So one of the things, and we went through a bunch of, we listed several of these things. And so I'm just going to comment on some of them here. These are just comments on what we said, what did we say? Duress, right? We said the court might set aside the contract in the case of duress. Somebody, holds a gun to your head and says, oh, you're going to buy this car from me for $50,000, right? So why would you, set that aside? Because it's not really a bargain, right? Just sort of thinking about what's the economic justification for, rather than saying, oh yeah, well this person was just being mean, right? You got to have an economic reasoning why you would set aside something under duress. And of course, what this is all about, the contract is about the fact that you can bargain, right? And tort law was about you're in a situation where you can't bargain, right? So why would you set aside a duress, right? Because it's not really a bargain. If there's a situation, if you are the courts and you're looking at this contract and you go, you know what, this really wasn't a bargain. This person was threatened if they didn't engage in the bargain, and so that's really not a bargain. It's really, what is it? It's really a transfer of wealth in some sense, right? The person that has got the gun at your head is transferring wealth to you by forcing you to go ahead and sign the contract. What about necessity? Right? We said necessity was another reason that the court might set aside a contract. Why would you say it makes sense to set aside a contract or to alter the terms of the contract if under this idea of necessity? What is necessity about? It's really a threaten to not act. right? It says, I'm not going to, you know, you run out of gas and a person comes by and you're out in the middle of the, you're out in the middle of Mojave Desert or something, and a person comes by and says, you know what, I've got an extra couple gallons in my gas tank and I'll sell it to you for $5,000, right? And it would, rather than they're forcing you to do something, they're threatening you to not do something, right? That's really what's going to go on. And so what you're really trying to do here is, if it's under a necessity, it may be that you say what's really going on is a transfer of income or wealth, right? I'm not just providing you with this, the gasoline, but I've charged you such a high price that it's really a transfer of wealth. And so the court might look at this and say, you know what, that was beyond what is efficient. So how would I look at that? When I'm looking at, if I'm the courts and I'm looking to see, hey, was this outrageous in terms of what they're charging you, okay? That it's really where they've threatened to not do the thing for you. What you got to think about is you want to have an incentive. Let me get rid of this here. Let's put it up here. You want to have an incentive for people to rescue others, right? We could think of it as the Good Samaritan. So how do you spell Samaritan? Anybody know? Okay, but I'm going to spell it that way. The Good Samaritan. Okay, so I don't want to make it so that, oh my gosh, I'm not going to carry I'm going through the Mojave Desert and I'm going to have an extra 5-gallon can just in case it come across somebody. Or let's say you have a company that goes out and it has a helicopter, and if somebody gets lost in the mountains, the helicopter will fly around and try to find them, right? So you want to have it so that there's an incentive for people to rescue others. So it may be that you have what you count as this was a necessity and it was more than what we would think was efficient in terms of doing that. You don't want to make it so that nobody's ever going to help, try to help somebody else, because I'm not going to, give you, sell you something and, you've set the price so low in terms of necessity. If you're the courts, I'm not going to help people out. So you're going to have to sort of think about what you want to do in terms of, you might want to have a higher level for something that's expensive to do, and if you might say, well, geez, $5 a gallon for gasoline, that's not too bad, but $50 a gallon for gasoline, that's more than anybody would need to do to have extra gasoline sitting around, right? But you have a question, Micah?
Oh, yeah, I guess that kind of answered, but I was wondering how this plays in with price gouging and things like that, and disaster circumstances, and then courts have ever, I don't know, prosecuted cases like or have taken on cases like this.
Yeah, I mean, again, you're talking about what about price gouging laws, right? And that would be the idea that, it would be sort of this similar idea that you have to get the gasoline, but then you have to sort of think through the efficiency aspect, right? If you have a price gouging law and you set the price too low, what's going to happen? You're going to get a shortage, right? If you have a price gouging law that says, okay, you can't set the price higher than equilibrium, right? That'd be okay, right? Well, just think back to ECON 202. If I were to set the, if I said, okay, here's the demand for gasoline, here's the supply of gasoline, and now there's a hurricane that's landing in Louisiana, right? So what will happen? Well, the demand curve will shift out to the right, right? People will want to pay more for than they did before for gasoline. And so what should happen? The price would go from here to here. So if we were looking at this necessity, we'd say, you know what? I want to have the gasoline there, right? So I'm going to allow a price that its equilibrium. If it's greater than equilibrium, then you'd say, okay, I could make a law that says you can't charge a price higher than equilibrium. Well, you won't create a shortage anyway, right? Because if you have a price up here, what's going to happen? I have excess supply, right? Quantity supply will be bigger than the quantity demanded. So that's a very good point in that price gouging laws, you could have them, and if you set it so that you had the efficient level of gasoline being sold out there, I'd want to let it wouldn't be a necessity violation if you set it at equilibrium. And if you set it above equilibrium, then it's not going to have an effect anyway, right? Because I'm going to have excess supply. So that was a good question. All right, what about impossibility? Okay, that was another thing that we talked about, right? I give you a list of a bunch of things that the courts might do to set aside a contract. What if you had impossibility? Just sort of what are some comments that we might think about if there was an impossibility? Well, if you had basically, should the promisor be held liable, and if so, what compensation should the promisee expect, right? Promisor doesn't deliver because it's impossible to deliver, right? That was the deal. So if you sort of think about that, promisor can't deliver, right? Because of this impossibility. Well, what you sort of think about there is, should you hold the promisor liable, and if so, what should the compensation be, right? And if so, what's the compensation, right? Could they be opportunity cost? We talked about different ways. Could they be reliance or opportunity cost or whatever, or perfect expectation? What should it be? Well, if you sort of think about it, what you want to do is you want to assign the risk to the party who could reduce or spread the risk more efficiently, right? You should assign the risk to the party who could reduce it most efficiently, right? So I got a risk that you're not going to throw the contract out, right? If I'm the promisor, you got a risk that if you're the promisee, you got a risk that the court's going to say, impossible to happen. Contract isn't void, or is void, right? So what you want to do is, if you're going to look at an impossibility ruling about when you're going to throw if you're going to throw the thing out or not because of an impossibility, you want to say, okay, yeah, it was impossible, but you know what? You should have known. You're the promisor. You should have known this could happen, right? You should have been aware that this could have happened. So it's like an unforeseen, unfortuitous event, right? There was a problem that came up. So again, it's not sort of rocket science here. What I want to do is I want to get people to efficiently take precautions. And if I know that if the thing becomes impossible, that the contract could be overthrown, right? But I don't know for certain, right? That's sort of the deal, right? I mean, when is the court going to say, yeah, we're going to throw this out because of impossibility? If you've made it impossible, if you did something that made it impossible, then I might force you to pay compensation, or I might force you to have specific performance, and you know that, then you'll be more likely to take the efficient precaution. Same thing about frustration of purpose, right? If, I want to, again, assign the risk to the party right? If you say, well, there's no reason to do this any longer, neither party is going to benefit from the completion of the contract, so let's just throw it out. What do I want to do? I want to try to figure out if, when you're entering into that contract, you want to make it so then when the court's looking at, okay, here's what happened, right? You're in the court afterwards. You look at what happens. If the one party could have taken more precaution or could have known, or they have a cheaper way of reducing the risk, then you want to make it so that they're the ones that are going to lose from the court decision. Okay. What about a mistake about what the object was that you were bargaining for? Okay, this is the last point we'll make. Suppose you have a mistake about what you were bargaining for. Right? And if you, in fact, we're probably won't get through all of this one here, but let's just think back and we'll follow up with this on Monday. This is really when we were talking about restitution, right? When we were talking about restitution, that's when you get, when this idea came up. If there was a disagreement about what the parties were bargaining over, the contract might be null and void because there really wasn't a bargain, right? And so we just say, okay, give the stuff back, right? So we'll talk a little bit more about that when we come back on Monday. We are now pretty close to finishing chapter 9. Again, that's what's going to be on the midterm, right? It's going to be 6 and 7 and 8 and 9. Those chapters basically on tort law and contract law. So we will have finished what we're going to be doing for the midterm about halfway through on Monday. What I'm really thinking about doing is doing the criminal law first, as opposed to I think the criminal law is a little more interesting. And if we get to the end of the semester, I'd rather have covered the criminal law than the legal institutions. That's sort of something you just sort of read on your own. So why don't you start the criminal law chapter for Monday, and then again. No office hours today, and we'll have the review session on Thursday. Somebody asked in the other class, I don't think it's going to be recorded, but right now I've started Zooming this class. So again, you can get into the Zoom by using my personal ID and password, or I can send out a link to the Zoom. Zoom records it, and I'll send out a link to the Zoom recording for that. All right? So, all right, then I will see you guys on Monday.